Welcome to Garden Views. Interesting conversations with interesting people who have done and/or are doing interesting things. So sit back and enjoy. Welcome into another episode of Garden Views, and we have one of our returning guests. We have attorney and colleague of mine, Farzad Panshiri, and we're going to sort of pick up where we left off during the entertainment IP trademark episode, which was very well received. So part of this will be sort of a part two of that, and then part of it will be sort of Farzad's journey, because he's tri-continental, and really quad continental, but we won't get into that part of it. That's top secret. That'll be for another show, I suppose. And he's going to do a little compare and contrast for us, because he's been an attorney in more than one country, not just more than one state, but more than one country. Yes, you heard me right. So, Farzad, first of all, thank you. How are you tonight?
I'm good. Thanks for having me again.
Oh, it's great to see you. And you know, I saw Farzad on LinkedIn. Somebody else now interviewed him on a little interview segment. So another person who I've interviewed who will now exceed me in this field. So that's terrific. I love giving the youth a leg up, so they can step on me on their way up. That's fine. So last time we left off, sort of, we realized we'd gone 90 minutes and really only felt like we scratched the scratch of intellectual property law. And I don't think that we can really do much more on that. And neither one of us does patents, but, you know, maybe I'll find someone who does at some point for that. But I think for entertainment purposes, patents don't come into play as often, but copyrights do. And we never really got into probably is the most common experience or exposure someone might have to a copyright issue. And that's typically what's now called the DMCA takedown notices, which stands for the Digital Media Copyright Act. So first of all, am I correct in that? And second of all, if you could just give a brief outline as to what that is.
Yes, the DMCA, that's correct. It's connected. So to explain that, I think we have to take a step back. So sure. We have to explain direct infringement of copyrights and secondary infringement. So direct infringement means you are the person who's infringing. Secondary infringement means you are not directly infringing, but you could be secondary liable. And there are two ways you can do that. One of it is contributory liability. So in that regard, you need intent, and you need to materially contribute to the infringing use of the copyright. So to spice it up and to like shorten it up a little bit, you need knowledge and participation. And the second way you can be secondary liable is vicarious liability. For that, you need control, so which contains two elements: right to stop someone from an infringing use, and the ability to stop someone from an infringing use. In addition to that, you need a direct financial benefit from the infringing use of the copyright. So to shorten this one up, you need control and direct benefit from that. And because of these secondary liabilities in connection with internet, I think that caused a lot of problems. That's why the DMCA Act came into place.
Yes, because the platforms, right?
Correct, exactly. I mean, literally everything regarding internet, if you're providing a platform, if you're the internet provider, anything, and someone is infringing, you could be theoretically secondary liable because you are providing the platform. So that was a big problem, and that's why the DMCA Act came into place. And
so let's slow down for just a second to let my mind catch up and see if I understand it right. It sounds a little bit like republisher liability versus publisher liability in defamation cases. So would the first case, would an example be, I'm a producer, I create, I basically copy whatever, Star Wars. Let's just say I completely copy Star Wars. It's total infringement. And then for some reason, Studio X, let's just say Hulu, for whatever reason, decides Disney isn't giving us enough of the bundling money, so we're gonna run your infringement, which they would never do. But so I'm the direct infringer, and Hulu would be the vicarious liability performer in there. Um, this is probably much more common on these platforms like Facebook, Twitch, YouTube, where you pretty much can put anything on there, and you have your terms and conditions. And I think that's sort of where you were going to get to. I just wanted to sort of try to make that distinction, if it's
exactly
with like a real life example, which might be easy for folks to understand.
I think that before, I mean, without connecting that to the internet, I think I remember there was a case where, so someone, I think those video recording machines or DVA or whatever they're called, they just popped up, and people started recording TV shows, which are copyrighted.
Mm-hmm.
So the question was, and the people sued the provider of those machines which are recording, and the court said they're not liable. They did not infringe directly, and they were not sued because of secondary liability. And that's I think a pretty good distinction.
So basically, they said
the person who are clicking on the record button, you're directly infringing. You're the last person who did the last act and last infringing act.
Right. So we just created something to record, not to infringe. It's sort of like the gun manufacturer saying, we just invented something to create something to shoot. We didn't tell anyone to shoot a person.
Yeah, exactly. I mean, for like video recording, etc. I mean, it does not necessarily need to be for infringing purposes.
Sure.
Guns, I mean.
Well, they don't. I mean, you could use it to shoot birds or targets or whatever. But I don't really mean to get into all of that. Guns is its own issue that's replete. But it's the same exact argument. It's just I mean, the context is less life and death, even if you put your life savings into a particular project. In which case, you probably shouldn't be copying somebody else's work.
But I think that clarifies the distinction whether you put whether you are the person who pushes the record button or not. You're just providing the tools, basically.
Right. So, I wonder if it's less clear. You buy people used to buy the bootleg, DVDs. They probably still do. Bootleg CDs, and they're not the recorder either, and they're a reseller. But they could be both, because they know that it's a bootleg and they're selling it and they're putting it out to the public. So it's one of those cases where they're certainly not the original infringer, but they have probably as much control, but they're at least they're at least vicariously liable.
Yeah, exactly. And the DMCA Act itself, it has like four main provisions. It's 512A, that is about transitory digital network communications. So basically, this one's protecting the internet providers,
right?
Because the internet providers, I mean, they obviously they help you to transfer the information, right? Transmit, routing, or providing connections to different people, and that's 512. So that's the safe harbor for them. It has certain requirements, of course. They need to comply with. And then there's a 512, section 512B, which is the system caching safe harbor. So you have, so for videos, for example, you have that buffering or that caching part, which is temporarily saving the parts of the copyrighted work on your system, and that's for that. And then 500, section 512C, I think that's what we're talking about. That's the important part. And 512D is about links, and they're very similar to each other. So 512C, that's the part where information residing on systems or networks at the direction of users. That covers that part. So that can be any kind of storage, that can be website, that can be Facebook, YouTube, anything. where you're the platform, where you're the provider, and you're offering the other people to post things, storage things, etc., etc. And it has specific requirements which are important. I mean, so to be able to use that safe harbor and not be secondary liable, you need to comply with those requirements.
Right.
And 512C for the websites or for the providers of storage of information, and 512D for links, so hyperlinks, they're very similar.
Okay. And is that where this DMCA takedown notice protocol sort of fits in? That's part of the deal, is that you have to have some process in place if you're a platform for a content creator to say, hey, that person was not able to use my stuff.
Exactly. That's where it comes into play. So the requirements are to be actually able to use that safe harbor. The service provider does not need to have actual knowledge of the infringing activity or constructive knowledge of the infringing activity. If they obtain actual or constructive knowledge, they need to expeditiously remove or disable access to the material. That's one part. Next requirement is if that the service provider does not receive a financial benefit from the infringing activity, and that he has basically right and control of that activity. If they can't control it, of course, they cannot do anything.
So it'd be stricter if the allegedly infringing content creator, not the original content creator, has a Patreon or gets super chats or even gets enough views to share ad revenue with YouTube because you're benefiting from the content, or is that not what they mean?
I think that might be in reference to one of the cases. I remember that what was it, Grokster or something?
Wrong guy.
You could download. You could literally download everything, or it was another platform.
Napster.
Not sure if that was one of those websites, or if it was a website offering cloud services, but they were directly stating in their advertisement, they were basically saying, oh, you can download it like $100 expensive software which are copyrighted. So they were literally saying, come use our services. You can get all these free copyrighted stuff, which is actually copyrighted, but you can get it here for if you sign up for free. So I think that might be what is meant by that eventually. And yeah, the third requirement is, of course, notification. So the upon notification or claimed infringement, that the service provider needs to immediately remove or disable access to that material. And these are the requirements. And in addition to that, the provider needs to have a designated agent registered with the U.S. Copyright Office, so certain information needs to be provided to the Copyright Office, and that agent needs to be designated. And the last requirement, the service provider needs a list of requirements for that takedown, basically. So that's basically the full list. But the important part is, of course, I mean, it's difficult to show if the provider had actual knowledge, constructive knowledge. How do you prove that? Right. Or if they had any financial benefits, if they're not really, like, let's say, stupid enough to say, hey, I'm infringing, I offer infringing content, come and use my services. So those parts are a little bit difficult. But on that,
is there any record keeping requirement that, let's just say that they had no reason to know that me on my YouTube channel that I infringe, but they get one DMCA, and let's just say I was not, I mean, I assume there's I know that there's a method for you to dispute whether or not you're actually infringing or not, and it may take a short period of time, it may take forever because there's no time period for the platform to actually respond, as far as I know. So that could be a fool's errand. But anyway, let's just say YouTube had no idea that Jeff Lippman is an infringer, but they got one DMCA notice and they took down my stuff. Are they now on notice as like a dog bite? The one bite rule has been satisfied, so they can only use that defense once? Or can they say, listen, a billion people use YouTube around the country. We can't possibly keep records like that.
I think that kind of depends on the rules they're having. I mean, each website, they have their own rules, but they need to certainly have those rules and state them. If someone is infringing, take down the stuff. If they keep continuously infringing, to eventually just delete that account, that possible account. I know that many providers are doing that.
Yeah, they have strikes oftentimes. I mean, they don't have to, but I imagine that's what they're trying to do, to say what is sort of de minimis or what is a pattern. And I think they basically have 3 strike rules, like 3 strikes and you're out within a period of time.
I think that the reason why they might do that is probably the constructive knowledge.
Yeah.
So it might not be actual knowledge that they know, okay, this person is infringing, but if someone keeps constantly infringing and you still let them on your platform, that could eventually be seen as constructive knowledge.
Yeah, no, I agree. It's definitely basically the scenario I just said. They have no idea that Jeff Lippman infringed. He gets one notice, but they have a billion users and they can't keep track of it. But at 3, at that point, at 2, there should have been, at 1, maybe there's a yellow flag, but it's a pale yellow flag. At 2, there's sort of it gets more orange. But at 3, red light. That goes on your do not fly list, so to speak. And once one carrier does it and does it successfully, they all sort of copy. Everybody reinvents the wheel, and somebody has to be first. And probably somebody in some room said, 3 strikes and you're out. Okay, sounds good. We'll see. I'm guessing it was more contentious and took more time than that, but that's I bet if you were flying the wall, that's more or less what happened. I want to quick fire a couple things to you and you can either debunk these myths or bunk these myths. I never hear anyone say I'm bunking a myth. I only hear debunking. So I'm not sure if I'm using the word properly, but who's to say I'm not? So the 7-second rule. If you use something for 7 seconds or less, it's not infringement.
7 seconds? I would not. I wouldn't say no. So we're talking about copyright infringement, right?
Yep.
And I think that really depends. Again, and that's something. Copyright infringement. It depends on a lot of factors. So, how much did you copy? Is the material substantially similar to the copyrighted work? I mean, taking a picture just takes a millisecond, and copying that might also just take a millisecond. So, there's 7-second rules. I think make sense at all.
There is no 7-second rule. There's just a 7-second belief. So
it depends how much you copy, if it's substantially similar, if you had access to that content, and then like regarding fair use, etc. I guess that's also fair use plays a little bit of a role. The quantity of how much you copied, was it the heart of the work? Was it kind of allowed? Is it like is fair use provide some insight? Like, was it fair use eventually? Was it allowed? So I think a lot of factors are playing a role. But in specific, I remember that there was some jurisprudence that someone. So I know there was a book. I don't remember who it was about, but they tried to promote the book, and some newspaper got the information about the heart of the book, and it was like one really important information, what that person did or what not, and they disclosed that information in the newspaper. So that was like a tiny little fraction or part of the whole book, but that was the heart of the work, and it was still considered copyright infringement. So
I know that there's the de minimis case from the movie Seven about a photograph that was in the background of a scene, and the argument was it's barely there, and nobody bought their ticket to see the movie Seven to see a photograph in the background of one scene. So I think they just tried to use. Go ahead.
Yeah, and I remember also there was another case with a pinball machine. in the background of a movie, and it was visible for a couple seconds, and I think that's where this 7-second rule might come from. It was just visible shortly, and really like 1 or 2 seconds or something, and the whole movie was like hours.
Right. It could also be something that the music industry has let it be known that if you play part of our song, or the movie industry, if you play up to 7 seconds, I mean, we're not going to bother you for something that small, and maybe that's gone around and it's turned into a rule when it's just maybe a certain industry standard. And I'm glad you clarified copyright, because if this was an audio show, rather a video show, and we displayed the Nike logo in the corner of the screen for 2 seconds, it might look like Nike's sponsoring us. And that would be infringement regardless of the amount of time. Now, if you were wearing a Nike shirt, that's not sponsoring Nike. Any normal person would know that just happens to be the shirt you're wearing that day. But even then, sometimes you'll see some producers who will blur out brand names on it, probably not because they're worried about infringement, probably because they're worried about alienating or pissing off their other sponsors who might be in competition with Nike. Or they may just be saying, we love Nike, but if they want their logo on our show, they need to pay for it. They need to buy ads. So that's that. And there's also the exceptions for fair use. So, none of what we're talking about is being able to use for fair use. So you're the local news and you're covering a Billy Joel concert and you hear a piano man playing for, 18 seconds. That's not copyright infringement because it's the news segment. But, Jeff live streaming might be, or probably is. Whether or not Billy Joel cares or not, or his record company cares or not, is a different story. All right. So other possible myths that we're going to bunk or debunk. I see all the time people go, or they print, or they have displayed on screen, I do not own the rights to this. And they think that that's going to insulate them. Is there any truth to that statement in written or oral form that insulates someone from infringement?
No. If they're copying the copyrighted work, and it is substantially similar to the copyrighted work, it doesn't matter whether they're saying, it's not my work, I'm just representing the work. Even if they say that it's the work of that other person, if they don't have a license, if they don't have the permission from the other party, from the copyright owner, to copy their work, to display their work, to perform their work, then it is copyright infringement.
Right. Now, I haven't litigated a case in open court in a number of years, but even I remember one of the exceptions to the hearsay rule is a statement against self-interest, which is basically an admission. You're basically making an admission when you do that. I do not own the rights to this, and you go ahead and do it. So you're infringing anyway. Now, whether or not,
Party admission,
yeah. Now, if I sing Mississippi Queen on Facebook, do they care? Probably not. But if I sang Mississippi Queen on TikTok and somehow I got, 1 million followers and monetized it, maybe they'd want a piece of that action. I don't know. And they'd be within their rights to do it, even if I said I don't own the rights to this music. All right. So those were a couple of the frequent myths that I sort of see out there, which people think, oh, well, that's definitely, that insulates me, and that's not really the case.
One addition in that regard. So I think what you said, that's exactly one of the main factors. Number one, because it's part of fair use. The fourth factor, the most important one, whether your infringement has, or infringing the copyrighted work, whether that has any potential effect on the market of the copyrighted work. So if you're a private person and you're just posting something and you're not actually commercializing it, you're not having any benefit from it, it won't probably have any effect on the market of the actual copyrighted work. To the contrary, people might get interested and they say, okay, I want to eventually buy that book or get that copyrighted work.
Right.
And in addition to that, you don't have money. You're not a business.
Right.
You're just a private person.
But the important thing is it's not about monetizing it for yourself. I mean, that's a factor, but it's about diminishing the monetary value to the content creator. So as you pointed out earlier, when someone else revealed a major plot point to a forthcoming book, they probably did not commit enough copyright infringement by volume, but because they took the heart of the matter, they did. They spoiled the book. And basically, even if that newspaper or whatever didn't make $1 off of that story, they still potentially killed other people buying the book because it was already ruined. The ending was ruined. So that was the monetary issue. So even if you ran a free website and you showed, I don't know, 10 minutes of Doctor Strange, on, a day before it came out, somehow you got that and you leaked, the ending, even if you were free, you still could have affected it, to some extent. And obviously the larger your membership and your followership, and if something went, quote, viral, end quote, that could still affect the monetary gain to the content creator. And with registered copyright infringement, there's statutory damages. You don't have to show financial damages if you can show loss. The interesting thing is, because of that, because new content you apply for the copyright then, and you may not get the copyright for several months or a year, you may think you got away scot-free with it and get hit with a lawsuit, 14 months later. Is the registered copyright, does it date back to the day you file for the application or no?
When you file for the application, no. I mean, you get the copyright with the creation of the work and with fixing it in a tangible medium. But then you file the copyright registration, so you can have the copyrights before.
Right. Can you still use federal copyright infringement suits even without the registered copyright?
Oh yeah, I mean, you cannot sue anyone. You cannot enforce your copyrights before court if you do not have a copyright registration.
So you see what I'm saying? I released Doctor Strange, Multiverse of Madness, whatever it was. Just to say it was June 1st. I have no idea. And I spoil the ending May 31st. So as of, they finish it, they file for the copyright, whatever, 2 weeks before June 1st, but they don't actually get the registered copyright until, October 1st. I've already spoiled it, but they don't have their registered copyright till later. Can I backdate my suit under federal law? Or do I have to find other grounds to file trespass or something like that?
And in my personal opinion, I do not think that it doesn't matter when you file the copyright. It is important when you got the copyright, when you receive the copyrights, not the copyright registration itself. The copyright registration, you can have your copyrights, and you cannot file for a copyright registration. And when someone infringes, then you can say, okay, I'll file a copyright, and then I sue that person.
Okay.
The only problem is detriment is, I think, you have like a few detriments, and I think you cannot rely on statutory damages. That's one of the
right, and attorney's fees, and you have to prove damages. But and you're right, there is no grandfathering. So people out there are probably like, huh? That's why there's another statute that says any redistribution or infringement is subject to criminal penalty, which can be subject to X amount of years in prison and up to a $250,000 fine. So there's criminal statutes which are regardless of the registration status. And there's actually Recording Industry of America and Motion Picture Association of America special police. I mean, they're designated to make arrests and press charges and all around the country. And they used to actually go to flea markets and look for those booths selling those bootlegs. I'm sure the whole world has changed. It's more probably cyber now. Anyway, so that's why there's the difference between the criminal act and the civil action. We sort of brainstormed it out here, live and in living color, or to those of you listening on the download, just on audio. But we didn't practice this. All right. So others, first of all, is there anything else in copyright or trademark that you wanted to cover?
No, I think we covered quite a broad range.
Okay. So with general entertainment law, I mean, one thing I want, this is mostly contracts and leverage. There are agents that often represent talent. Agents in some states, maybe all, are required to be attorneys. That doesn't mean they have to have law practices. the agency might be their law practice. That might be their job. Others maybe not. Maybe they don't have to be licensed as an attorney to get that license. I don't know about all 50 states and the district, but I do know that in Maryland, for example, you need to be an attorney to be certain types of talent agents and not others. So those of you who've gone to the mall and your 15-year-old was told they can be a model and you sign one of those contracts, modeling in Maryland, they don't need to be, those agents don't need to be attorneys, but sports agents do. So there's that. And as far as, so I don't think that we really can do an expose on contracts, but, obviously the bigger you get, the more leverage you have. Every now and then you'll hear of an outlier case where some sort of fundamental fairness came in, and the American Idol season 1 sort of comes to mind because those terms were so onerous. And that's the exception. It's really only because everybody watched American Idol. The same thing happens to startup bands and new talent every day all over the world still to this day. But because it was American Idol, they, the courts maybe stretched a little bit, and I don't believe that that's been precedent. I think they just settled it and, American Idol took care of it going forward. And, I assume some of the other shows have as well. Do you have any light to cast on this topic?
No.
Okay.
I'm not even sure if I was here when American Idol was displayed in the TVs.
Yeah, it was. Well, I think it's still on in some form. Anyway, yeah, it was probably around 2002 when it was season 1. Anyway,
I was certainly not here. I was back in Germany then.
Right, you were alive. You just weren't here.
Yeah, I was not in the U.S. then.
Yeah, so this is mostly contracts, and yes, there's often and there's employees, there's independent contractors, there's members of guilds, which in some cases can live in both worlds. Some content creation companies, publishers, producers, studios use only unionized or guild labor, so they use those contracts. Those usually provide for minimum day rates or minimum weekly rates, also sometimes minimum royalties. And of course, the bigger you are, the more royalties, and, you can negotiate for credits like executive producer or things of that nature, and points on merchandise and things like that. So there's a big difference between what Robert Downing did, way back when, and what Robert Downing Jr., could do by the time Iron Man 3 was around. Anyway, I don't really think that we have the time or energy to go into that right now, and that's not really your bailiwick, and frankly, it's not so much mine either, at least not these days. So let's go into what is your bailiwick, which is you. So let's hear the biography of Farzad, and you can take it into the law as early or late as you like.
Yes. So my background is a little bit different. My country of origin is Afghanistan. I grew up in Germany and I studied law in Germany. I passed the bar exam in Germany and started practicing also there in Germany as in-house counsel in the area of trademarks for a IP service company. And I decided to move to the US and went back to law school, did my LLM in intellectual property law, and became an attorney in the US and started practicing trademark and copyright law in the US too.
LLM is a master's degree for law, for those who don't know. So it's, most of us have we all have a JD, and we all have passed the bar exam to call ourselves an attorney. You don't need to pass the bar to call yourself a JD. You just need to graduate law school. But
exactly.
Yeah. But an LLM
I do not have a JD.
Yeah. So LLM is an advanced degree, and this, I presume, allows you to practice in these federal areas.
As a foreign educated lawyer, you do not need to go do everything at law school. At least in some states. And New York, for example, they have a requirement that if you have a certain amount of credits and you went to an ABA approved law school and did an LLM program or like whatever program, and you comply with those minimum requirements, like those credits and the specific classes, then you are allowed to sit for the bar exam.
Oh, okay.
So I do not need the full JD because I have already a law degree from foreign country.
You have the equivalent degree in Germany. What's it called in Germany, by the way?
It's called actually state examination. There are two different state examination. Like number one, first state examination is basically the equivalent to the JD. That's the that's JD. That's the university part. Like at the university, that's subject matter basically. And then the second state examination, that's kind of like the bar exam. So that includes the procedural stuff and the subject matter. And yeah.
Why are the Germans so boring? State examination and state examination. I mean,
yes, the first state examination, second state examination.
Wow, very efficient and economical. Not a lot of time spent work on the naming conventions there.
Yeah, but it's also very tough. Like the first state examination, it takes a week. So you have 1 week exams. I believe it's like, I don't know what it is, like 3, 4, 5 exams or something. And the second state examination, that takes like 2 weeks. So the bar exam is, instead of 2 days, 2 weeks.
Yeah, our exams can take a week. They can even take 2 weeks depending on what classes you're in. Probably longer depending on the law school. But
well, I'm talking about the bar exam.
Yeah, no,
our bar exam is like 2 days.
Yeah, our bar exam here in Maryland is 2 days. There were some people who were clever and took the Maryland and the DC bar at the same time, and so it was 3 days for them. Or some people did that with Pennsylvania, or even further foreign and flew, and very ambitious people. So good for them. So that's interesting. So yeah, so you were able to waive in because of you had the equivalent degree and a certain amount of hours under your belt that convinced the bar of at least one state that was eligible, and then you were able to apply for the federal bar, or did you do it vice versa?
The federal bar?
Well, did you join the federal bar first or the state bar first?
I'm not understanding. Is there a federal bar?
Uh-oh. Yes, there is. Yeah. I'm a member of the Bar of Maryland. I'm a member of the Bar of the District of Columbia. I'm also a member of the Federal Courts of Maryland and the Federal Courts for the District of Columbia. I'm also someplace, a member of the Bankruptcy Court in Maryland. Now, with federal admission, you can waive into any federal district, and the same applies for any bankruptcy court. But with state courts, that's not the case. I think that I had to wait 5 years to waive into DC, and that was maybe only because my multi-state score was high enough. Because I'm a genius. No, this is not unusual.
Yeah, I just have the New York State bar examination, and I would have waived in DC too. The only problem with that was DC has different requirements for foreign educated lawyers, so they require additional specific credits and specific classes, which I did not have because I did my LLM in intellectual property law instead of general U.S. law.
Well, what happens when you are a New York licensed attorney for 5 years? Can you waive into DC then based on New York?
No, I think if I'm not confusing, I believe there's a way to waive in DC if you're working in DC for 5 years as an attorney. Then you can waive in without any further complications. If my understanding is correct, I don't know if I got that information right.
I don't know either. I guess it apparently is not a major concern of yours because, like most sane people, you're not anxious to waive into the DC and practice law in DC. Hopefully nobody heard that in DC, but it's a nightmare.
And it depends what you're practicing, actually. I mean, if you're practicing trademark and copyright law, it's federal law, you can practice it in any state. So it should not matter.
So your New York licensure is sufficient for that type of federal practice. But if you were going to go into so what about if something became litigation outside of the trademark office and you had to go to the United States District Court, say Fourth Circuit or whatever, would you then have to be I mean, I know that you could be sponsored pro hoc vice, and for those who don't know,
Yeah.
that's when a lawyer licensed in that state sponsors you and says, I can vouch for this attorney. Let them practice before this court for this case. And that's usually granted, and usually the attorney license that say sort of has to sit there as sort of local counsel to make sure you're adhering to the rules, etc. Sometimes that gets dismissed or otherwise after whatever the judge deems an appropriate period of time, or sometimes it's the entire duration. But or are you able to practice in the United States Federal District Court because you are the attorney of record in New York for the federal trademark?
Yes. So my understanding is that you are allowed to practice before federal courts with any bar examination you have from any state that allows you to practice before federal courts, but not before state courts. So if there are any state claims, I mean, many states, they have their own also trademark law. For example, I know that New York has some trademark rules, and you're basing your claims on state claims. I would not be able to practice outside of New York. So sue someone before the state courts.
But if it was a trademark claim, you believe you could?
Yes.
Okay. I don't know whether you're right or wrong, so I'm not going to push it any further. All right. So what are some of the main differences between German jurisprudence and American jurisprudence? We here in America, we get our law mostly from British common law. A lot of places do. Some people might have heard of, may hear that Louisiana is different. They might hear Napoleonic Code because Louisiana is the only state based on French civil code. The basic difference is British common law is that stare decisis, meaning that you're to respect the decisions of prior courts, unless there's some compelling reason not to. French civil law is the rule is that you don't have to. Every case is a case of first impression, or although from a practical standpoint, they probably mostly adhere to it just for sanity's sake. But what's the difference between German jurisprudence and what we might consider American and British common law? We're going to ignore Louisiana for the moment.
Yeah, and I think you kind of summed it up like that. The most important factor: U.S. is a common law country. Germany is a civil code. So just to clarify in that regard, I mean, most of the countries are nowadays a combination of the two. So there is no strict civil code and no strict common law. The jurisprudence in Germany, like from the highest courts, it has the value of being basically law too. So in that regard, yes, the jurisprudence is important in Germany too. But I would say, like, just from practicing here and also the case law, etc., you have a little bit more. Everything is more codified in laws, so they have it literally everything, and all the claims, everything is in those law books. And you have that a little bit lesser here in the US. So I see that in privacy law, it's in Germany, it's based on their amendments, and they have specific laws, and according to the amendments and the jurisprudence of the, it's called the Second Amendment, or it's called Article. In Germany, it's the amendment is called Article, so it's Article 2, and everything is based on that, and you just have to read the jurisprudence and the law, and you understand that. And privacy law is based on that. In the U.S., privacy law is based on partly jurisprudence, partly HIPAA law, partly, like, it's splittered up everywhere. And the preamble of the amendment or whatever, they're basing it. So it's a little bit less, I would say, structured. But yeah, so Germany jurisprudence plays a role. Civil code is playing, of course, also a role, a bit stronger role than in the U.S., I would say. In the U.S., it's a little bit, the courts are a little bit more flexible regarding basically interpreting the code. Of course, they're not fully flexible because that's the job of Congress to make the laws. But much more flexible than Germany, I would say. And another big example, I would say, is a very huge difference is, for example, in trademark law. A common law country, you have a common law trademark. In Germany, no common law country. So let me explain first what is a common law trademark. A common law trademark is if you do not file a registration for it, and you're just using a brand as your trademark in connection with specific goods or services. So that gives you certain geographically local common law rights. So you have a common law trademark just based on use without filing it anywhere. In Germany, you don't have that. It's not a common law country. So either you file a trademark registration with a patent trademark office in Germany and you have a registration, or you don't. And then you don't have any rights.
Does Germany have its own trademark laws, or is it part of the EU bloc, or do the countries each have their own still?
Yeah, the countries they have all their own laws. So Germany has their own trademark laws. So if you want to file just a trademark in Germany, you can file it just in Germany if you're not interested in the rest of the EU. Okay. It is of course part of the EU. So if you file a trademark application with the EU IPO, the EU Intellectual Property Office, then you receive protection for all the EU countries. So that's the difference. Of course, it might be a little bit more expensive than just one country. But if you're filing for 4, 5, 6 countries, it might get almost as expensive as an EU trademark. So in most of the cases, it's worth it to file for an EU.
So if you file directly with the EU, you are covered through everyone in the EU bloc, but you're paying for that coverage. It costs more than most, if not all, member countries individually, and maybe a handful of member countries individually in the aggregate. So it's an economic decision. So okay.
But it is cheaper, so especially with the so-called WIPO system, Madrid system, it makes it easier to file in those international countries through one organization and file basically or expand your trademark in those designated countries.
I know that your family left Afghanistan when you were 5, so your recollections of Afghanistan are probably faint, if any. I don't know if you've gone back to visit or not, but do you have any knowledge on the legal structure of Afghanistan versus the U.S. or Britain, any more than anyone else? Or no, that's just never been part of your world?
Not really. I mean, I don't have much knowledge. The only thing I know is that they're kind of they're many countries that kind of split up religion and state. Those factors that kind of split it up and said we don't want them together, which makes sense. And I know that that was not the case in Afghanistan. So
right. Well, there's Taliban and then post-Taliban and pre-Taliban and now Taliban again. There's Sharia law. It's also getting debatable sometimes here in the U.S. as well. So I don't know. Yeah. That's yeah. That church and state division was a pretty good idea. So sorry for anyone who doesn't agree, but you're just wrong.
I agree.
Yeah. Whatever. If I lose listeners on that hill, that's okay.
Did that in a very, very drastic way.
What's that?
I know that Turkey did that in a very drastic way to split up religion from state.
Yes, they did.
I don't know if you heard about that, but Ataturk. So and that's just hearsay. So if anyone from Turkey is actually hearing that, they're like, "Hey, dude, you're wrong. Sorry for that." But that's just what I heard from friends who are Turkish. And they told me that Ataturk, basically the father of Turkey, he wanted to split up. He was very modern and thought very modern, and he wanted to split up the state from religion, just separate these two entities from each other, and he just brought in all the religious people, all the mullahs, and Islamic priests basically brought them all into one building and just blew them all up.
Yeah, in very, very simplistic terms, I understand that's the difference between a sultanate and a caliphate, or an emirate and a caliphate. Though with anything where there's a monarch, that distinction can be extremely blurred. But I think sultanate versus caliphate is that sort of universal. I'm going to say sort of because I don't know 100%. All right. You like it here? You like it here in the U.S.? You having fun?
Yeah, certainly.
Better than Germany? Boo, Germany?
Warmer than Germany.
Yeah, okay. Warmer than Germany. Food better?
Who's better?
Food better. You know who's better. We're better.
I would say there's much more diverse food here in the U.S. In Germany, you just have lesser exposure to like other foods, and here in the U.S. you can literally find everything. Like from each region of the world, you'll find a restaurant here.
Yes. I don't want to start an international instance. We like Germany, especially lately. Last few decades or so, very good. So yay Germany, and I've got plenty of German in me, so can't really bag on them too much. So yeah, I thank you for us. We went overtime last time, so I really made a pledge to myself to not go overtime this time. So where are we at here? We're still under an hour, just over 45 minutes. So unless you have any things that you really want to share with the world, why don't you just tell people where they can, first of all, if you do have anything you want to share. And secondly, if people can support you, find you, follow you, where can they do so?
Absolutely. Yeah, no. So we didn't start with a disclaimer, so let's end it with a disclaimer.
Oh, so smart.
This is not legal advice. This is just for educational purposes, and we are not representing the thoughts or ideas necessarily of our law firm, Dunlop, Bennett and Ludwig. And yeah, if you have any questions, if you have any, if you want to ask certain questions or just talk to me and ask something or not ask something, you can feel free to reach out to me. The name is Farzad Panjshiri, FARZAD PANJSHIRI, and you can find me on the Dunlop, Bennett and Ludwig website or on LinkedIn. So yeah, happy to connect. Feel free to reach out anyone, and always happy to connect to any colleagues.
Excellent. Well, Farzad, thank you for your generosity. And to the audience, make sure to check him out. Give him a follow on LinkedIn or Professional Network, etc. As far as everything else, I hope that you enjoy the show, and I hope that you give us 5 stars and rate and review the show and share with your friends. And if you like this content you're checking out for the first time, Garden Views tends to be topical, not always legal, but there's a whole lot of it on there. A lot of stuff about extrapolating to law of the space and other legal issues that I think are of sort of national or maybe even international interest. But there's some other stuff too. There's some random interviews, and I just dropped a show on the moon, which was which was almost completely fact-based, as opposed to my show on Mars called The Red Planet, which was probably 88% fact-based, but enough fiction that I decided to put it on Garden of Doom instead. And you can find Garden Views and Garden of Doom on the Garden of Doom feed, where you can find all your fine podcasts, or at the following networks: the PW Hustle, the PWC Network, the Wrestling Soup Network, Hameen Media Group. And I think that's it for the networks for those shows. If you want to look for me in other places, at EckersfellMD on Twitter. I'm also on LinkedIn. And I'm on Facebook and someplace else. Can't remember right now, so it's probably not that important. And whatever song comes after this, I don't own the rights to this music, but we're not monetizing it, and it's de minimis and all of that stuff. But I'm probably committing copyright infringement anyway, but
educational purposes, fair use.
Oh, right. This is for educational purposes. It's fair use, and the song is going to be tied in. So thank you. See, he's a good lawyer right there. Jumped right in and protected his... See, even a lawyer representing himself has a fool for a client, and you just saw that in action. This was a teachable moment, folks. Teachable moment. All right. Thank you, Farzad, both times. And thank you all for listening in. And you'll hear us next time in Garden Views, and hopefully you'll check out Garden of Doom as well, and you'll enjoy that content too.
Look at them yo-yos, that's the way you do it. You play the guitar on the MTV. That ain't working, that's the way you do it. Money for nothing and your chicks for free. Now that ain't working, that's the way you do it. Let me tell you, damn guys ain't dumb. Maybe get a blister on your little finger. Maybe get a blister on your thumb. We got to install microwave ovens, custom kitchen deliveries. We got to move these refrigerators. We got to move these color TVs. Move on, move on. Mama, she got it sticking in the cameraman. And we could have some. And he's up there. What's that? Hawaiian noises. He's banging on the bongos like a chimpanzee. Oh, that ain't working. That's the way you do it. Get your money for nothing. Get your chicks for free. We got to install a microwave oven, custom kitchen deliveries. We got to move refrigerators. We got to move these color TVs. Listen here, now, that ain't working. That's the way you do it. You play the guitar on the MTV. That ain't working, that's the way you do it. Money for nothing and your chicks